while we are in a transition, I'll introduce panel 4, which is following up on the discussing and dissecting the legal framework envisaged in 1950 and subsequently being developed in terms of international criminal law or common fight against impunity, and looking at the various objectives and set out goals as well as crimes falling within that framework. So the last question and the last panel is going to look at which crimes concerns the community as a whole and discussing the reasoning behind this classification and related developments. We have with us 3 prominent experts in the field, and I will like to introduce them very briefly because we do have 45 minutes, so please read up on their extensive bios on our platform and follow up there. But we have today with us Professor Olympia Beku, who is the Professor of Public International Law and the head of the School of Law of the University of Nottingham. She is the Deputy Director of the Case Metrics and member of the Advisory Board of the Centre for International Law Research and Policy. She has extensive experience in post-conflict situation and has undertaken a number of capacity building missions. We also have with us today Advocate Batohi, and I will try to keep the bio very briefly, so excuse the brevity. But she is currently the advocate with the prosecution office in South Sudan. In 2000, she was appointed regional head of the Scorpions unit in KwaZulu-Natal and led evidence at King Commission of Inquiry into cricket match fixing. In 2002, she was appointed first woman provincial director of public prosecutions in South Africa, and she has served as legal advisor to the prosecution of the International Criminal Court. Since 2018, she is the National Director of Public Prosecutions in South Africa. Last but not least, we also have Professor Neha Jain, who is a Professor of Public International Law at the European University Institute and Associate Professor at the University of Minnesota Law School. She has worked at the Max Planck Institute for Foreign and International Criminal Law, served as visiting professional at the International Criminal Court, and held fellowship at the Stellenbosch Institute of Advanced Studies, Lauterpacht Center for International Law and I-Courts. Thank you all for joining us today. And we will ask the first question to Professor Beku, which is very simple in questioning, but probably much more complex in answering. The question that we would like Olympia to look at is, which are the crimes, apart from expanding the application of genocide, war crimes, and crimes against humanity, are recently being rediscussed or newly considered as potentially included in the group of core international crimes? What challenges does this bring? Olympia, the floor is yours.
Thank you very much, Yolana, and thank you all for the kind invitation. It's always a pleasure and a privilege to be speaking at the Nuremberg Forum, and I'm sad not to be physically in Nuremberg this year. Deciding which crimes we ought to consider as being part of the so-called core international crimes sits at the heart of the fight against impunity. The normative question of what makes an international crime has occupied the writings of international criminal lawyers since the early beginnings of the field. Which type of conduct deserves to be criminalized, and would a positivist act, such as inclusion in an international treaty, automatically turn such conduct into a core international crime? Or do international crimes need to shock the conscience of humanity or be of concern to the international community as a whole, as our panel title declares, before they're classed as core international crimes? So since 1950, we've come to appreciate that 4 core international crimes are widely accepted, albeit the definition of aggression in the ICC statute took an awfully long time to be agreed upon, despite the Nuremberg precedent. And obviously, as you know, the negotiations, the intense negotiations at Rome and Kampala, where it was adopted. It is, I think, early days to say whether the definition of aggression in the ICC statute is workable in practice and whether it may, in fact, need to be amended in the future. But where core international crimes have been tweaked, it has mostly been on the occasion of the creation of new tribunals. With the Rome Statute system, any changes have been made through a process of amendments. So let me start with genocide. The definition of a crime of genocide, for many the crime of crimes, has remained unchanged since the 1948 definition of the Genocide Convention. Where the opportunity arose to amend and perhaps expand the definition of genocide, and I'm referring here to the drafting of the ISTY and ISTR statutes, and then during the Rome Statute negotiations, this was not taken up. The definition of genocide has remained the same, despite calls to increase the protected groups or expand the punishable acts envisaged in the crime. The term genocide, you see, is commonly perceived differently in social sphere compared to its legal meaning. Calling something genocide adds drama, if not gravity. And perhaps it also adds pressure on prosecutors to bring about a genocide charge. Over the years, calls to include cultural genocide, politicide, which is the killing of political groups, gendercide, killing of members of a specific sex, have gone unanswered at the international level. Having said that, a number of states have expanded their domestic definitions of genocide to include, amongst others, social groups or any other stable group following the Akayesu judgment of the ICTR, etc. What are the challenges of broadening the scope of genocide? On the one hand, it might lead to more charges of genocide being brought by prosecutors. On the other, it might dilute the stigma attached to genocide. To my mind, a serious case of crimes against humanity can be as important as one when genocide is charged. And it is crimes against humanity that I shall turn to next. Let us recall that the Holocaust was tried as a crime against humanity at Nuremberg. Since then, this category of core international crimes has been decoupled from the requirement to have been committed in conjunction with an armed conflict and has seen an expansion in the punishable acts. I would like to mention the development of the provisions relating to sexual violence in particular, which have developed considerably since Nuremberg through the ad hoc tribunals and to what we have now, which is a very comprehensive set of provisions in the Rome Statute. Of course, the fight is not over. I would argue that as a living document, the Rome Statute ought to reflect the reality of the crimes committed on the ground. So new crimes have been added to the Rome Statute, such as enforced disappearances or attack to peacekeepers, and so on and so forth. I shall return to other possible new crimes that are currently being discussed in the final part of my presentation. But before that, I'd like to focus a bit on war crimes. Criminalizing violations of international humanitarian law is not new. War crimes is the oldest category of core international crimes. A crucial distinction between war crimes committed in the course of an international armed conflict and those committed in non-international armed conflicts persists, with fewer war crimes in the latter category. As with other crimes, the expansion of the list of war crimes has happened mostly with the creation of new tribunals, but also in respect to the Rome Statute through an amendment in Kampala and subsequently in 2019 by an amendment through the Assembly of States Parties process. I'm referring here to the war crime of starvation of civilian population, which was originally limited to occurring only in the course of an international armed conflict. In December 2019, a new paragraph 2E19, was inserted, which criminalizes the use of starvation of civilians as a method of warfare, also in non-international armed conflict. Closing the gap between war crimes committed in an international armed conflict and non-international ones is important in my view, as it would afford greater protection to the victims of such crimes. I think perhaps when it comes to war crimes, we ought to consider this for the future amendments, not least because of the changing nature of the conflicts, which increasingly involve non-state actors and are mixed conflicts. Of course, getting states to agree to such a radical change in the understanding of war crimes is not always easy. But we do have some shining examples from domestic legislation incorporating the Rome Statute, which does away with the distinction, thus offering greater protection. I'm of course referring to Germany, but also there are other states, South Korea, Belgium, have taken this approach. So the innovation comes from the domestic level in this instance. Having looked at core crimes definitions, I shall now turn to those international crimes that sit on the periphery of core international crimes, stricto sensu. Let us recall that when the proposal for a permanent international criminal court was rekindled by Trinidad and Tobago, the crime that was exercising them was not genocide, nor crimes against humanity, not even war crimes, but drug trafficking. Is there space for the so-called treaty crimes in the modern conception of core international crimes? The crime that I think comes closer to that is perhaps that of terrorism. Indeed, in 2010 in Kampala, there was a proposal by the Netherlands to include the crime of terrorism per se in the Rome Statute. During the original negotiations in Rome, terrorism was considered, but was not thought as one of the most serious crimes of concern to the international community as a whole. The attacks on the Twin Towers on September 11th, 2001, which gave rise to the war on terror led by the United States, but also the rise in organized and widespread piracy on the high seas, linked to organized terrorist organizations, helped to refocus minds. It was against this backdrop that the Dutch proposal was made. Include the crime of terrorism as a placeholder position, following the precedent that we had with the inclusion of aggression in Rome, and then subsequently, through a working group, define its elements. The proposal did not go very far, not least because the lack of a consensus surrounding the definition of terrorism as a crime remains. I see difficulties in operationalizing a crime of terrorism in its own right as part of the Rome Statute. With a view to the future, what are the new crimes that are of concern to the international community as a whole? The destruction of our planet and the protection of the environment is at the forefront of everyone's minds at the moment. Last week, the Human Rights Council overwhelmingly voted to recognize the right to safe, clean, healthy, and sustainable environment as a human right, and to appoint a special rapporteur to monitor the impact of the climate crisis on rights. The urgency is there, but can it be an international crime? Earlier this year, an independent expert panel for the legal definition of ecocide, convened by the Stop Ecocide Foundation, defined ecocide as unlawful or wanton acts committed with knowledge that there is substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. The term unlawful or wanton acts suggests that conducts need to already be criminalized. And wanton has been defined as reckless disregard for damage, which is clearly excessive in relation to the social and economic benefits anticipated. But how will clearly excessive be determined? And is it implied that it is acceptable to damage the environment prior to reaching this clearly excessive threshold? A number of questions remain, in my view. Since 1950, the substantive doctrinal developments of core international crimes has brought about changes to the definitions. Expanding the scope of the provisions would increase the workload, require more resources, and in some instances dilute the stigma and gravity attached to core crimes. Although international criminal law is not static and needs to move in with the times, I would urge for a cautious, steady, and considerate rethink of some of the provisions within existing core international crimes, and a serious consideration as to whether additional crimes and punishable acts should be elevated to the core international crimes category. It is on us all to navigate future issues, which we will face within the wider context of our global community. Thank you.
Thank you very much, Olympia. What a list of dissecting challenges and practices and way forward and recommendations all in one. Thank you. I think now the challenge is on Advocate Batohi to combine these challenges. And the question for Advocate Batohi is, where does theory meets practice? And what additional challenges can be added from the domestic prosecution of core international crimes? And in addition to what Olympia mentioned, which I think was already a mixture of challenges arising also from implementation, or at least the complementarity work that she's doing in her trainings or various research activities as such. Then it's, yes, the time passing by. I'll give the floor to Advocate Batohi. Thank you for joining us.
So firstly, let me say a good afternoon to you, Yolana, and to my fellow panelists, Professors Bekau and Jane. It's a pleasure to be on this in a different context, having left my international criminal law, well, that part of my life 2.5 years ago to come back to South Africa. But it's very good to be here to now share some of our experiences and challenges from a prosecution perspective. So, you know, South Africa has a very rich history and really strong jurisprudence with regard to international law. It was, in fact, the first African state to domesticate the Rome Statute into national legislation. And this was done in terms of you know, Section 231 in our constitution. And we also enacted the implementation of the Rome Statute of the International Criminal Court Act in 2002. I will just refer to it as the South African ICC Act. And so, you know, these core international crimes over which the ICC exercises jurisdiction are all listed in the South African ICC Act, and so have become statutory crimes in South African national law. So we have a really strong legal framework. But in addition to that, in South Africa, I'll demonstrate our jurisprudence and the activities of our civil society and lawyers has also shown that we have really exceptionally skilled lawyers in international law and a very rich international law jurisprudence. But then I'll talk about the challenges notwithstanding that. And one of them is, you know, notwithstanding that, you know, with the legacy of apartheid in South Africa still very much with us, we are still trying to ensure accountability for the crimes that were committed, particularly in the context of crimes against humanity. So we are still struggling to bring justice to victims of atrocities that were committed during the apartheid regime in South Africa. And time is not on our side. You know, suspects and witnesses are dying. Loved ones of victims are dying without seeing justice being done. So there's a lot of pressure, particularly of late, for us in the NPA and together with our colleagues in the police service to hold to account those that are responsible for apartheid era atrocities. But very quickly, this pressure on law enforcement to deal with these crimes must be seen in the context of a criminal justice system in South Africa that has been weakened through about a decade of what has been referred to commonly as state capture, which was really characterized by grand, almost institutionalized corruption, exacerbated by COVID-19 pandemic. And so the dynamics in South Africa are very, very complicated. And the weakening of institutions over this period means that the resources and the capacities and capabilities needed to really hold those responsible for these atrocities is really very, very is insufficient. And I'll touch on that a little bit later, mindful of the time. And you're also aware in this complex environment that South Africa had taken steps to leave the International Criminal Court. But I want to remain optimistic that this will not happen. But it's in this cauldron really that we have to reflect on impunity and what is needed to end impunity for these crimes in South Africa. So firstly, I'll just reflect on what I referred to as a very special place that international law has in South African law. There have been key cases in South Africa that have involved the consideration of our South African ICC Act, and particularly in the context of crimes against humanity committed in another country. And that was the one key case. And so, as you all know, a core principle of public international law is the issue of state sovereignty and the fact that the state dictates that sovereignty dictates that states are empowered to act at their discretion within their own territory. And crimes against humanity is a crime that attracts universal condemnation, and therefore all nations have an interest in its prevention and in addressing impunity for these crimes. And so in the context of South Africa, in addition to our constitution, which I mentioned, there are various regional and sub-regional instruments that in fact allow us to exercise universal jurisdiction, albeit with some limitations with regard to some of these core international crimes. And so, I'll just deal with one of these, and I can deal with the limitations later. It's, the issues of practicality, etc. If there's time, we can talk about that. But the one particularly important case in South Africa was the National Commissioner of our South African Police Service versus an NGO called the South African Human Rights Litigation Center, referred to as SALC. And this was very briefly, there were allegations that members of the opposition party in Zimbabwe had been detained for several days and tortured by the Zimbabwean police, and allegedly as part of a widespread and systematic attack on the opposition in the run-up to the national elections. And so the South African NGO, South African Litigation Center, sent a memorandum to the South African Police Services and the National Prosecuting Authority, which I now head up, to initiate investigations and to look at prosecutions. And it also set up the legal basis for contending that South African authorities could do this, although the crimes were committed in Zimbabwe. And so the result of this, however, was that the South African Police Service refused to do that. And so the NGO took the matter to court, all the way up to the Constitutional Court. And our Constitutional Court emphasized and established that South Africa's domestic and international powers and obligation to prevent impunity. They emphasized this, and also to ensure that perpetrators of these crimes committed by foreign nationals beyond our borders can be held accountable. And in fact, in a court lower, the Supreme Court of Appeal, that is before it went to the Constitutional Court, had held that our police have the power to investigate these crimes. But our Constitutional Court went further and found that this was not just a power, but it was a duty, which arises from the Constitution read with the ICC Act. And as I said, there are certain limitations. In essence, issues relating to reasonableness and practicality, and these must be determined on a case-by-case basis. And we've had another case which is referred to as the SADC tribunal matter, where this is not criminal. Well, maybe I won't mention that. It's more in the context of international law, not international criminal law. So in the interest of time, I won't mention that. But there was another case worth mentioning, and that is the al-Bashir matter, which I'm sure many of you that are interested in this website will know about. The ICC had issued warrants of arrest for crimes committed in Darfur against Mr. al-Bashir. And, these were forwarded to South Africa for execution because of Mr. Bashir coming to South Africa for official business. And so what had happened was the South African government did not arrest him. And the main reason that they said for it was he was an incumbent head of state, immune from being arrested, and surrendered to the ICC. And the High Court in Pretoria, as well as the Supreme Court of Appeal, found that South Africa had violated its obligations under international law and domestic law by not arresting and surrendering Mr. al-Bashir to the International Criminal Court. And so these are just examples of key decisions in South Africa that shows that really have contributed to a rich jurisprudence that we have with regard to international criminal law. But that is on that level. But when you come back to holding people accountable within our country for crimes committed in South Africa during the apartheid era, there have been some key prosecutions against some of the so-called persons in the apartheid regime, more sort of higher level operative, Eugene de Kock, Ferdy Barnard, that have, were prosecuted criminally. But these cases are particularly challenging because all of the state's resources were used to cover up the tracks of people. And there were elaborate schemes to fabricate alibis and so all to create false alibis. And so it's really very, very challenging, and notwithstanding the resource issues that I talked about. And so this has actually proven to be a very, very challenge. And also we are looking at 50, 60 years later, that, it presents its own challenges. But together with the police, we are setting up a specialized it actually ideally needs a multidisciplinary capability, but we're setting up an investigative capability together with a dedicated prosecutorial capability to really collaborate and try to bring these cases to book. There are many investigative units like this, in many parts of Europe, Canada, the States. I won't talk about that in too much of detail because of time, but we do acknowledge that in order to deal with these cases properly, we do need to have these specialized capacities. And so, ideally after our TRC, also where we had a truth and reconciliation process, these cases should have proceeded speedily, those that either did not apply for amnesty or were not granted amnesty. But for various reasons, I told you it was a complicated country, but for various reasons, including political interference, these cases were not taken to court. And so now, years later, with all of the challenges, we're really trying to ensure that, the victims and witnesses and families do receive some level of justice. So in conclusion, what I'd like to say is that, the foundations, the cornerstones have been laid in South Africa. We have the legislation, we have good jurisprudence, but we really need to ensure that, our country's international and domestic law commitments, we must honor these commitments. We as states cannot be seen to be tolerant of impunity for alleged perpetrators of international crimes. And, from a South African perspective, we cannot be seen to be a safe haven for those who commit international crimes, both with regard to perpetrators of crimes committed beyond our borders, but importantly, crimes committed within our own country. And so this really needs to be done globally. And if all states, carry out that responsibility, perhaps there will be no need for an international criminal court, because all of these matters will be dealt with because of states' obligations to do this. So it needs to be done globally, and in particular in Africa. So with those few words, I'm going to stop, and I look forward to questions. Thank you very much.
Thank you, Advocate Batohi, for these reflections and adding additional challenges to already the list that we are running throughout the day. I will now ask Neha to join us and reflect on the following question: would reinstating complicity to core international crimes as an international crime offer any advancement to the fight against impunity? If so, please provide reasons why, and if not, then please also let us know your reasons behind the answer. And we look forward to your reflections.
Thank you, Yolanda. So like my colleagues, allow me to thank you and the Academy for this opportunity to be part of this terrific conversation with, of course, my wonderful colleagues on the panel and with all of you online who we unfortunately can't see in this webinar format. I would have loved to do this in person, especially in the stunning historic location in Nuremberg, but I'm glad we get to at least be together in this beautiful virtual courtroom. Since the time we have together is rather brief, rather than focusing on the doctrinal complexities of the general law of complicity, I want to focus on one specific aspect of it, and that's the one that concerns the business of mass atrocity. So instead of discussing who orchestrates mass atrocity or who commands mass atrocity, or even those who stand by and do nothing, all the things that have been the traditional focus of complicity talk, I will focus on international criminal law's economic blind spot. That is how international criminal law conceives of the relationship between commerce and atrocity. So the question then is, who are mass atrocities funders and profiteers? What do the Nuremberg Principles, since we are celebrating the 75th anniversary, have to say about their responsibility? And as we write the long history of international criminal law and think through what the future might hold and what we might want it to hold, what is the best way to capture the nature and the role of corporate complicity in serious wrongdoing? So the logical starting point for this exploration is the Nuremberg Principles themselves, insofar as they reflect some of the ideological roots of modern international criminal law. So Principle 1, as most of you in this room will know, states that any person who commits an act which constitutes a crime under international law is responsible, therefore, and is liable to punishment. And no less a commentator than Antonio Cazzese has referred to Principle 1 as essentially based on the IMT judgment, which states that crimes against international law can be committed only by men and not by abstract entities. And it's only by punishing individuals who commit these crimes can be enforced the principles of international law. But while this may be an accurate commentary on the source of the principles' textual inspiration, if we are to treat the principles as a living document, as Olympia said earlier, should we interpret them to exclude the responsibility of abstract entities? Or should we be guided by the Nuremberg trial's initial commitment to address the unholy trinity of corporatism, Nazism, and militarism that led to the Second World War? And here, to add to this growing list of challenges, ICL does face a few additional challenges, normative, conceptual, as well as pragmatic. Principal amongst these is international criminal law's repeated invocation of the mantra of individual blameworthiness. Even though the doctrines and practices of international criminal law are actually suspended in a tension between the liberal commitment to individual responsibility and also romantic notions of collective guilt. So international criminal doctrines of responsibility, such as organizational responsibility, criminal conspiracy, joint criminal enterprise, they all have an inescapably collective dimension. And for some scholars, this backsliding to the collective is an inevitable consequence of the fact that crimes such as genocide or war crimes or crimes against humanity are in fact, as Jose Alvarez calls them, crime of the state, which is that they're crimes that arise out of organizational tendencies or collective choices and not merely individual action. And my argument would be that these collective tendencies and choices that contribute to mass atrocity today are not merely or mostly those of the state, as Advocate Batohi just said, but equally those of its private counterpart, which is the corporation. And so haunted by the specter of collective guilt, whereby if everyone is guilty, then no one is guilty, international criminal law has traditionally balked at the concept of this form of collective criminal liability. And despite the claim that the leitmotif of the IMT trial was exposing Nazism, militarism, and economic imperialism in an orgy of revelation, leading industrialists were only indicted in the course of the subsequent trials under Control Council number 10. And while some have argued that the trials of IG Farben and Krupp and Flick represent a nascent form of corporate criminal responsibility qua the corporation, this interpretation is not widely accepted in scholarship. And the emphasis there is instead that the defendants were charged in their private capacity as corporate officers and not as the corporation as such. So you fast forward a few decades, and a French proposal to introduce a more limited form of corporate criminal responsibility during the drafting of the Rome Statute also failed to garner sufficient consensus. And it's only recently that we see international, regional, and also domestic efforts for corporate accountability for mass atrocity. So you have, for example, the decision of the Special Tribunal for Lebanon, the appeals chamber in the Al-Qayyad case, holding that corporate criminal responsibility is on the verge of attaining, at the very least, the status of a general principle of law, which has been described as the foundation for further developments of the liability of corporate entities in international criminal law. And this is so even though the ruling of the STL relates only to personal jurisdiction over corporations for the contempt of court, rather than for responsibility for an international crime as such. Another more ambitious regional innovation, and undoubtedly Advocate Batohi would know more about this, is the recognition of corporate criminal responsibility for international crimes in Article 46C of the 2014 Malabo Protocol to the Statute of the African Court of Justice and Human and People's Rights, though there are, of course, issues of ratification there. But more exciting are the domestic developments that highlight the indirect ways in which corporates might be complicit in international crimes, though some of them are focused on the liability of corporate officers, again, rather than on the corporation as such. For example, you have the successful prosecution of the two Dutch businessmen in domestic Dutch courts as complicitors in international crimes. So Cornelius van Anraat, who delivered the chemical TDG, which was used to create the mustard gas that was used during the Saddam Hussein regime, and who was then convicted as an accomplice to war crimes through the use of chemical weapons. And the basis was that it was evident from just the quantity of the TTG supplied that it would be put to military use rather than agricultural uses. And then you had the timber baron, Gus Kovenhaven, who was convicted as an aider and an abettor for supplying weapons and material and personnel to the former Liberian President Charles Taylor and his armed forces. And more recently, you have the high-profile French case of Lafarge, which is charged with aiding and abetting crimes against humanity by virtue of having paid millions of euros via a subsidiary to Islamic militants, including ISIS, to keep its cement factory in northern Syria running during the early years of the civil war. And just last month, France's highest court issued a landmark ruling in Lafarge, stating that one can be complicit in crimes against humanity, even if one doesn't have the intention of being associated with the crimes committed. And if you knowingly pay several millions of dollars to an organization which is actively criminal, that actually suffices to constitute complicity. Even if you don't, in this case, Lafarge is only pursuing a commercial activity rather than actually trying to further the aims of ISIS. This does not mean that Lafarge will automatically face trial in France, but now the matter will be referred back to the magistrates to consider whether or not the charges should be reinstated. So those seem like fairly promising developments, but of course, a few such swallows don't make a summer. And so hearkening back to the notion of responsibility that was reflected in the Nuremberg Principles, should the modern international criminal law of complicity be guided by the economic case that was propelled but was ultimately never fully realized in Nuremberg and the subsequent trials? And if so, what version would we want of criminal responsibility for corporate complicity? And that would represent a truce between the liberals and the romantics in criminal law. And this brings me to another aspect of the accountability framework, that is the regime developed in the Nuremberg Principles. And that's the faith in criminal responsibility, which is implemented by means of punishment. And so recent scholarship has suggested that the long shadow cast by the Nuremberg model of privileging the criminal law as the vehicle for accountability has actually proved detrimental for recognizing the complicity of economic enablers of mass atrocities such as corporations. So you have scholars like Leora Bilski who've argued that civil litigation and settlement may be better able to account for the complexity of corporate involvement in mass atrocity. And Bilski draws on the experience of transnational class action litigation of the 1990s and the 2000s, involving victims who were trying to seek civil remedies from corporations that were involved in Nazi atrocities. And she claims that this form of transnational Holocaust litigation, which is a hybrid of international criminal law and American structural reform litigation, is a much more promising accountability mechanism for corporate participation in international wrongdoing. To be sure, this is by no means the only or even the most widely endorsed position on what potential criminal law has to pursue accountability for economic drivers and agents of mass atrocity. But as we continue to write the next few chapters of the book of riches that is bequeathed to us by the Nuremberg Principles, it would serve as well to embrace the idea of criminal law norms as just one brick in the accountability edifice for the participation of corporate actors in mass atrocity. So just adding to the list of challenges there that my co-panelists have thrown up, and back to you, Yolanda.
Thank you very much. I'm sure we all have many follow-ups and reflections, but I would like to give the floor to all of you. So I will ask you to provide reflections on anything that's been mentioned in the past 40 minutes, and then also provide your concluding remarks so we finish around 5 o'clock time before we start losing people, because it's quite a long day for everyone. And I will start in the same order, if that's okay with you. So Olympia, please, the floor is yours.
Thank you. I think we are all on the same page here. I can totally see Advocate Batohi's contribution as being a very important one, particularly on the on the domestic side of things, the future of international criminal justice, in my view, is domestic. And if we are going to fulfill the promise of the Rome system of justice, we need to pick up the baton. I think she provided some very good examples from South Africa, which I really appreciate. With regard to Professor Jane's contribution, I think this is also a very important aspect, corporate complicity, but also the financing of international crimes and financial investigations, which I know the ICC was engaging in as well, even though it's not part of the Rome Statute, is something that I think we will hear a lot more of in the years to come. So my two concluding remarks is that the fight is not over. And I think we will need both to strengthen the existing system before we try to expand it, but also, take into account the domestic implementation, take into account the domestic challenges and the corporate complicity, which besides, the states is important in realizing the fight against impunity, I guess.
Thank you very much, Advocate Batohi. The floor is yours.
Yes, thank you very much, and thank you to the fellow panelists for a really interesting discussion. Ranging from the academic side in terms of potential new international crimes, which has, ecocide, terrorism, drug dealing, all of these hugely important issues. But, it's the system of international criminal justice is so complicated. You're right. I mean, it really, if states do take on their primary responsibility to deal with these issues, hold people accountable, that is where the solution lies. But regrettably, as someone said, there are very few states that actually, well, I'm not sure how many, maybe very few, it might be a bit harsh, but that actually align with the lofty principles of international law. Because when it comes to these principles and national interests, very often it's the national interests that actually trump things. And so there's no common understanding around these, global understanding around these issues. So there's always going to be huge challenges. But at least if there is a strong groundswell of committed states, those that have signed up to the Rome Statute, that actually really are committed to strengthen the system. Because I think it's going to be a long way from domestic states, actually. There's some, you mentioned some of the cases, Ms. Jane, they are green shoots and it's great, but I think we're far from where we want to be. So the answer still is really to strengthen the system of international criminal justice and working very, very closely together with states. And yeah, it's the only court we have, so we really need to strengthen the system. And there's just sufficient, there's too many atrocities across so many different, crime types that really need to be dealt with very decisively. So thank you very much for the opportunity.
Thank you very much for your reflections. Professor Jane, the floor is yours.
Thank you. So just to echo my fellow panelists, I think what we're seeing now is sort of a stress test moment for international criminal law. It's going through this challenge of a backlash. It's going through this period where everyone wants to put everything into the international law bucket, with the expansion of the crimes, with the expansion of the complicity mandate, with the expansion of all the things that go into this bucket that we now call international criminal law. And I think one way to try and help ICC deal with the stress test is to actually say it doesn't have to do everything. So the future might be domestic, but the future might also be regional. So that's one element that we haven't emphasized equally. But the future might be a combination of also empowering regional institutions, at least in places where they're strong, and activists such as the Inter-American Court, for instance, which has been quite activist and progressive in its criminal law jurisprudence. So we might need to do more with our partners at both the domestic and the regional levels to preserve the core of what we care about in international criminal law without overwhelming the international level.
Thank you for these wonderful reflections. I would like to invite our director back on screen to officially thank you for the wonderful presentation, as well as the presentation of other colleagues and experts in the field, before we turn to a brief reflection on the day of the event. So thank you from my side, and I look forward to your questions in the chat over the next day.
Thank you very much, Jolana, and let me thank wholeheartedly not only this panel, but all panels that have been with us and have been inspiring us with their contributions on this discussion. It's indeed a pity that we can't talk from person to person as we have done for so many years. And I promise you that we will make everything that is in our power to have the next event in Nuremberg again here on these topics of international criminal law that touch upon us so deeply. Well, if I would look back to today's discussions and also to this panel, the one thing is very clear to me: although we are far away from being in a perfect environment, the Nuremberg Principles stand. And we are not going back to a situation that happened 47 years after the Nuremberg judgment was rendered, where nothing had happened, where Biafra and many other catastrophes have gone unpunished, where no court was taking care. It started back with the ad hoc tribunals, and what we see now is a landscape which is actually a promising one. And indeed, if I look at my own country in Germany, I've been as a student, a young student actually, been following the Majdanek trial in my own hometown in Düsseldorf, and the hatred, the arrogance, the ignorance of people, diminishing the prosecutor, ridiculing the witnesses. This is unthinkable today, and I'm very happy that we have now in Germany more than 100 investigations ongoing in core international crime cases concerning Syria, Afghanistan, Iraq, and many others. The Office of the Prosecutor General has grown from, I think, 2 people at the beginning to now over almost 30 people in 2 different branches. And that is something that will not be going back. And I think this is a success. And whether the Nuremberg Principles are respected all over the world, I think they never will be, because they are principles. The Nuremberg Principles do not establish a law, a codified law, or the principle of legality. There will always be crimes which will remain unpunished, but the principle cannot be taken away. And I'm very, very sure it will be steps like the regionalization and the domestic cases, which will put a very, very strong element to this. The corporate liability is one very important element. Many people are looking at the moment also to Sweden, where the Lundin case is ongoing, which is also a milestone case from my point of view. And this shows that the net is going to be tighter in the future. And if we can contribute with our discussions here to this awareness, then I think we have paid our share also to that. My personal belief is that it will take another couple of years, hopefully not decades, and elements like the French and others' initiative to block the veto rights in the Security Council in core international crime cases are quite promising, although it might take a while until we get there. But it is also an angle that nobody had thought about when the Nuremberg Principles were actually formulated and adopted by the ICL. Nobody thought about non-state actors at that time and many other things, which we currently discuss, and that is actually what is interesting. And we see this shift. This shift is interesting. I have been with the ICC, as many of you know, from its early days. And at the beginning, it was unthinkable that the ICC would ever engage officially in capacity building activities. Now the new chief prosecutor, Karim Khan, has appointed a special advisor on knowledge transfer. And that shows that the whole thinking has changed, and he has been applauded for that. That's the good thing. So it's now recognized that the court needs also to contribute to this capacity building in other parts and other countries of the world. This is a huge step forward. I'm looking forward for the discussions tomorrow as well. It's going to be as interesting as it was today. We still need to discuss the question, are we going to fight impunity, or are we going to end crimes. That is, of course, the ultimate goal, which we also had in mind, and Jackson has actually formulated it. We can't survive these crimes to be committed again. It wasn't about punishment of perpetrators, it was about preventing future crimes. And I think this is the ultimate goal that will remain on all our desks. So many, many thanks today for all these discussions. It was great to see some familiar faces after a couple of years. Again, I'd love to have done that personally, but the times are as they are. Nevertheless, and even the more, I'm grateful for your participation and for the time you have devoted to this conference, and I look forward to hopefully seeing you again very soon in person in Nuremberg. Back to you, Jolana.
Thank you, Klaus, and thank you again, everyone, for the time, expertise, dedication, and engagement through interactive platforms, and really making it as close to meeting in Courtroom 600 as we can in the given situation. We are planning to do a bit more substantive reflection on day one tomorrow at 12:30, where we are trying to summarize all the points being discussed and also open the questions for the remaining 3 panels in terms of either challenges that are being identified so they can pick up on them, or in terms of suggestions taken forward, and then trying to see how various complementing positions can be put together. We do also have a side event on Courtroom 600 with the Memoriam Nuremberg trials that's scheduled for 10 in the morning, where we have the 2 experts from the Memoriam joining us and explaining the history of Courtroom 600. So trying to really bring in the momentum of the history Courtroom 600, the importance of it, and really the recent developments and the situating within the Nuremberg and Nuremberg region. And we also have scheduled a brief section on About Us, which is going to be led by my colleague and our senior officer for capacity building, Ms. Brack, at 11:45, if I'm still on schedule. Yes. So thank you very much. And we appreciate all your time. And yes, to the speakers, all your patience with the technical test runs that we had done up until today. But we are very happy that to the extent it was possible, it worked really well. And we look forward to seeing you all tomorrow.